Hi, this is Shashank,
Hi, I'm Aishwarya.
and welcome to the CCG Tech Podcast.
Hey, Shashank. So, what are we talking about today?
We speak to Sérgio Branco, co-founder of ITS Rio, about internet regulation and data protection in Brazil and lessons for countries like India. Would you want to talk about Professor Branco?
Like you said, Professor Branco is the co founder of the Institute of Technology and Society. So, that's ITS, which is at Rio, which was founded about 10 years ago. So, that makes it one of the oldest organizations working in this space in Brazil. They work on issues relating to internet regulation, copyright, intellectual property, democracy, and related areas. I know they focus a lot on privacy, freedom of expression, and access to knowledge. And they also offer a lot of education and training and capacity building programs, which is part of also what they were doing at the summer school. And so, in this episode, Shashank, do you want to talk about what we cover?
Yeah, before that, just wanted to mention that Professor Branco, including students from Brazil, this year attended our annual summer school, and it was great to have them. About the episode, we're going to cover how the landscape around internet regulation is changing in Brazil, also the future of internet regulation in Brazil, bit about the fake news bill that Brazil currently has, a bit about data protection in Brazil, and what lessons could India learn from, let's say, the implementation of a data protection law in Brazil.
Yeah, I think it's been really interesting to talk to Professor Branco because this is one of the few opportunities we've had, at least so far, to talk to someone who's not based in the global north. And so a lot of the context and socio-political sort of like realities are similar. And so I think it's a really fun conversation.
Yeah, actually, I'm very excited that we're talking to Professor Branco because he's from the global south, one, and from Brazil too, which is great. I think I'm really happy that we got that opportunity to talk to him. Listen, there's a lot in common between India and Brazil, right? They're both global majority countries, have different contexts and socio-political environments to the global north. Although between them they have different cultures, but similar issues. And it'll be interesting to see how both countries are tackling some of these issues on their own. We're also in the middle of this transformation or a watershed moment in internet regulation in the world, of course, in India as well. A data protection law may be getting, through Parliament very soon. There is a law to replace the current Information Technology Act called the Digital India Act or Bill. um, and we're also hearing similar things in Brazil. So, yeah, I think that's why we thought that it's a very opportune moment to talk to someone like Professor Branco. We asked Professor Branco what are the big shifts and changes that he's seeing in Brazil, and in obviously internet law, and what are the new kinds of challenges that he's observing there.
Fantastic question because it's important not only to Brazil but also to India and to many countries to think what is important in regulation. And I'm very happy to mention you that about 10 years ago, ITS really helped to create this most important law in Brazil. We call in Portuguese Marco Civil da Internet, which means the civil framework for the Brazilian internet. And for some people, it is called also the Constitution of Brazilian Internet. It's a law full of principles that has been the main pillar of Brazilian internet in the last 10 years. However, as we know, internet has also changed a lot. And the challenges that we have now are very different from the challenges that we had 10 years ago. 10 years ago, for example, the main discussion was around the liability of intermediaries, which is also a concern now, but it was a different perspective because we didn't have at any time any idea of how to build a robust system of liability for intermediaries. And we ended up with our rule is that if the platform, the intermediary, the website, does not have a court decision telling it to remove a content, to take a content down, it will not be responsible. So this is our main rule. But there are others. For example, if the content relates to nudity, intimacy, or sex, then a notice would be enough. You don't have to wait for a court order. So this was one of the main topics by the time. A second one was net neutrality. And the third one was data protection. And the Brazilian system on data protection was really incomplete until 2018, when we approved our data protection law. So the civil framework, the Marco Civil da Internet, was our first movement to regulate Brazilian internet. Then we have also other kinds of regulation, but the data protection law is also very important. But now we must go, I believe, to a second round of regulation so we can face the actual challenges that are in Brazil, but not only Brazil, certainly in India and many other countries also.
We asked him to elaborate on challenges from the Brazilian perspective.
When we look back 10 years, we didn't have things such as fake news. Of course, fake news have always existed. It is not something new that comes with the internet in the last 10 years. But we didn't discuss it. When the civil framework for Brazilian internet was created, we didn't consider fake news or misinformation or disinformation or attacks to democracy. We in Brazil had, in the beginning of this year, a real world attack to democracy because some governmental buildings were invaded by people who were in Brasilia, which is the capital city. Right. And all these movements and actions were taken by people coordinating in WhatsApp groups, etc. So these things were not at stake when we discussed the internet regulation of 10 years ago, but they are now. And they are extremely important because they are extremely dangerous. But it's also very difficult to regulate them in only one way. I don't think it is possible to make platforms liable for any content. It will not be enough. If we change the rule and say, no, look, if people publish something like fake news or attacks to democracy, this person must be, the platform must be liable, it will not work. We have to also think who is behind these publications and profits with these publications, either financially or with the power it gives to these groups. So this is one thing we have to take into consideration, not only to look at the individuals, but look at the whole system. Right. And this is not very easy. We don't have one answer. We might have to face this reality with many responses. There are other challenges. For example, what we do with algorithmic decision making. How liable are platforms for that? We also cannot, according to Brazilian law, just ask platforms to reveal what their algorithms are, because there are some secrecy behind that belongs to their business model. So there is a very delicate balance that has to be found that will include how the public sphere works, how we protect private interests of the companies, and of course, how we protect the freedom of expression of the individuals. It's not easy, but it's important that we discuss this.
Yeah, so Professor Branco was talking about a lot of things that we're all having to deal with today with sort of the revised new version of the internet that we have right now. So things like fake news didn't really exist 10 years ago, like you were saying. There are lots of questions about content moderation, misinformation, and disinformation that we have to address. And one thing that I think is really useful to remember as we're trying to address this, especially through regulatory means, is that there's no single right answer and no single way to address these challenges. This is part of what we're also trying to do here in India right now, right? So we have our fact checking amendment to the intermediary liability rules. So just for context, this would allow the government to appoint a body to fact check news about the central government, and then they would be able to label any piece of information as fake or false or misleading, and then have it removed from social media platforms. Again, the platforms would otherwise be at risk of losing their safe harbor. So this body hasn't been notified yet. This is currently being litigated before courts. But there's a similarly contentious bill that Brazil has been looking at over the past few years, which we asked Sergio about. This isn't about fact checking. Not his bill. The bill in Brazil is about tackling fake news. And so here's what Professor Branco had to say about this.
So you also meant misinformation or disinformation and not fake news? Is that something that's popularized by certain politicians? And should we explain what safe harbor is? Maybe for people who don't know.
Yeah, hopefully. I think
Yeah. Right. Okay. So safe harbor basically means that an online platform, let's say Instagram, um, has protection for information that you or I put on it. So let's say I put some illegal content on Instagram. Basically, the safe harbor provision gives protection to Instagram for that content and says that I should be liable for that content, that illegal content, and not Instagram. So tried my best to sort of keep it simple.
Yeah, so here's what Professor Branco had to say about the fake news bill.
Yes, because of these challenges, now we are discussing in Brazil new regulation in several aspects. For example, artificial intelligence. We know that Europe is proposing a regulation on artificial intelligence, and so Brazil is following, like the data protection law was a Brazilian response to the GDPR in Europe, and now we have to do something about these new challenges, and one of the things is a bill of law concerning fake news.
Yeah.
About 2 weeks ago, we had a huge event in Brazil discussing one of the main aspects was that, and we can see that there is not a consensus on how this law should be made. The problem that I believe is that the Congress is trying to approve the law as soon as possible without the due discussion with not only civil society, but also economic groups, etc. Because when the civil framework was approved 10 years ago, it was approved after 5 years of discussion with all the stakeholders. And it led to deep discussion. And this week we were saying that Marco Civil was a law in which everybody who had an interest in it lost something. And this is good. When everybody loses something, it's because the law is not for only one specific group. Right. And we haven't debated this fake news project so deep in a way that everybody is losing something. We have to discuss it even more, especially because there are some things in the project that are not related to fake news. They are trying to include some copyright aspects imported from the European directive that are not related to fake news. Those the so-called tax for links. If you share a link of news on a social network, you're supposed to pay. This is not fake news. This is much more related to copyright. They also want to provide a kind of immunity to all congressmen on the internet, but it can be very, very dangerous if politicians have the right to say the most absurd things. Of course, they have to be immune to a certain extent so they can express freely what they think and what they are fighting for. But this cannot be so broad that allows them to for example, share hate speech. So we still have to debate the law more deeply. It's not ready to be approved. but we are afraid it will be in the next weeks. I hope not.
Give a bit of context behind what Sergio was saying. Basically, the fake news bill in Brazil is an overarching platform governance, digital content governance law. One of the biggest problems with the law is that it puts onus on internet companies, search engines, social messaging services to themselves find and report illegal material, instead of, let's say, courts identifying illegal content and then telling them to remove, or a government authority identifying such content and telling them to remove it.
Yeah, like you were saying, this is essentially what Safe Harbor relies on, right? The fact that someone else tells you what to remove, and then you only are liable if you don't do what a court or government order does. And so that sort of really inverts that model on its head in this bill, from what I understand.
Right, right.
The other thing that it also does, I mean, it does a lot of other things, but one of the other things that it does that it's been criticized for is that it proposes that companies, so in this case, platforms, would have to pay content providers and copyright holders for materials that they post on their websites. And so, again, like whether or not you agree or disagree with this, again, whether the place to do this would be a digital sort of overarching legislation or not is another thing that's come up a lot. And so, yeah, so essentially it is quite contentious. It hasn't passed yet since we spoke to Sergio as well.
Right. So we asked Sergio what he thinks is the trajectory for internet regulation now in Brazil, considering that they already have a data protection law. They have courts that have given important decisions in this field, and with this fake news bill being in the pipeline. So here's what he had to say.
I wish I knew. I would become very famous and perhaps rich if I knew where we are going to. But trying to be practical, we've mentioned here, we have this fake news project that sooner or later is going to be voted and approved, I hope with substantial changes to what it is now.
Yeah.
We have also a project to create a law on artificial intelligence. It is very, from my opinion, it's very, very, very weak. We have to, it's only principles, and from also this practical perspective, I don't see much substance there. So we have to improve it, this project. I think we are looking at Europe. Europe is, my impression is that Europe is going ahead and passing several legislative initiatives to regulate internet, so it becomes a little inevitable, like it was with GDPR. So DSA now will be probably to where Brazil will be looking in terms of, because this project of fake news is not enough. And as we're discussing now, the challenges of the internet, one of these steps we have to take is to talk about content moderation. And we will need what we are calling the self-regulated regulation, or to regulate self-regulation. And this is one of the aspects we will have to face, to create rules that will be followed by platforms, to make it more comprehensible and clear, how the terms of use may be used, to individuals know what they can and what they cannot do. Because I think one of the problems, this is my impression, is that several social networks took a lot of time to enforce their terms of use. So now we have, this is common in Brazil, I don't know in India, but we have, for example, politicians who have their profiles taken down. And this is very controversial. But I think it's controversial especially because from the beginning, the social networks didn't took one step after the other. Like, look, this you cannot publish. This will be taken down. They were, I believe, very permissive, allowing a lot of things that could be considered illegal according to the terms of use, and they did nothing. And then we came to this extreme situation in which the only solution is to shut down, to take down whole profiles of politicians, whomever they are. So we need rules that are better, with procedures, so people can really understand what they cannot publish, and if they publish, what are the consequences. And this is not something that has been made in the last years in Brazil. I would guess that in India and in other countries, in the United States, I see they were not doing that, and even in Europe. So let's hope for better procedures to make safer this balance between publishing and taking down what is illegal or what is against the terms of use.
And we asked Sergio what he thought about some of the limitations that global majority countries like India and Brazil need to think about when they're drafting these laws. And here's what he had to say.
I think that we have the world is global now. The platforms are operating everywhere. So we, for good or for bad, we must to get consensus on some aspects, because it will work only if everybody has the same standards. But we must not, and this is a must not, copy foreign laws only because we admire or think they are more they're in front of us in terms of regulation, etc. So we must look for inspiration and see, well, this seems to be a good idea, and but let's adapt it to our own countries and our own situation. I'll give you an example of something we were talking right now. In the GDPR, you can find an article which is the 17th, if I'm not mistaken, about the right to be forgotten. And when the data protection law in Brazil was imported somehow from the GDPR, we did not include the right to be forgotten. And this, in my opinion, is a very good solution, because I don't like, not even a bit, about how the right to be forgotten is framed in the GDPR. So I think we have to be very aware of where we are looking for inspiration, because the copy and paste most of the time will not work if we do not take into consideration our own circumstances. For for example, so when we look at the civil framework for the Brazilian internet, we see that one of the values that we can find there is to protect small companies against unfair competition. And this is something that we have to have in mind, that the small companies in the market must be protected against the big players, either they are national or international. So this is a way to look at our own market and create a law thinking about who is working and playing the market in Brazil. So it's difficult to have only one way of considering how to legislate, but it has to be more fluid, like in everywhere. We cannot import a legislation or even an article. We have to have in mind that the whole system in our country depends on searching for inspiration, but not copy and paste.
Yeah, so like Professor Branco was saying, there are differences in the way that regulations work across different countries. There are different regulatory standards just depending on your socio and political context. And so the kind of laws and regulatory solutions that work in a place like the UK or EU might not necessarily work in a place like India or, in this case, Brazil.
Talking about data protection law, we know that Brazil has had a data protection law for a few years. Something we are actively working towards in India. Hopefully, we'll have soon an act on data protection, an actual law.
Yeah, so actually, data protection's been a core sort of focus area for CCG for a very long time. And I know that Shashank, you and I have been working on this report. Now we can stop saying have been working because the report is out. But we worked on this for over 2 years for the Nations Development Program. So this looks at, there's meant to be a guidance for states on how to frame effective data protection regulations. So broadly we know what a good data protection law should have. Um, but that's not all there is to it, right?
Quite smooth there, Aishwarya. I see what you did. Yes, we have been working on data protection for a while. It's one of our core subject areas. Uh, Coming back to Sergio, we've learned and we've heard that you can have a great data protection law, but you need effective implementation and enforcement, and ensure that, for example, regulators have capacity to enforce the law. So we asked Sergio what are some of the lessons around implementation and enforcement that he has seen or insights he's drawn from the Brazilian experience.
Well, our law was passed in 2018, and since then we've been discussing a lot its implementation. I think it is a law that in Brazil would say that everybody's aware of. So it's a law. I don't know how to translate in English, but that is the law catches. You know that everybody is aware of the law and is worried about the law. First thing is that the law is, this is very interesting. The law is very conscious about the importance of data protection under a system of privacy. So the idea of privacy is beneath there. And we have, the law was very detailed in the way you can use anybody's data and for which purposes. Something that also helped is that academia has written a lot about that. And I think this is important because it reinforces what is the meaning of those words, because law has to be interpreted somehow. So this is a role for academia, for you. I hope you will be able to contribute with the public debate here in India concerning data protection. And we also had to create an institution in Brazil that is a kind of supervisor of how the data protection works. And companies are very worried about this institution has not found so far any company, but they are afraid because also sooner or later fines will be issued. And companies are going through also a very detailed compliance process. So from civil society, from academia, from individuals to companies, everybody is worried. We still have some practice that seem a little strange. When you go to the pharmacy, you give your national number to the pharmacy so you can get discounts. And what they do with that, we don't know. But if some years ago we didn't know and we had nothing to do, now we might not know, but we know what to do. And we know how to enforce the law if the pharmacy is using your national number, your federal number, for unauthorized purposes.
So that's been a very interesting conversation that we just listened to. So I thought it would be good to maybe talk about three things that we're taking away from this conversation. So one of the first things for me that really came out through this is that content moderation is a very tricky thing to govern and address. There's no real solution that can answer all our content problems because nobody can agree on what it is the internet should look like and what kind of speech should be allowed. And so really the need for multifaceted and also a variety of solutions to address this issue of bad speech online, whatever that means, is something that really struck me from this conversation.
You're right. One size fits all. We shouldn't look at that approach especially on content moderation. Another thing I think I took away from that conversation was we know that countries who've had more experience with drafting some of these laws, some countries in the global north, especially the European Union, with the pace that it has been renewing its internet regulation. There are certain principles that we can borrow from them. They can be baseline principles, which of more often than not are also based in our constitutional principles and democratic values. Um, but of course, there may be specific policy problems that we see locally in countries like India and Brazil. And we want those problems to be well defined so that the policy solutions that we can arrive at address those problems.
The third thing is that I think we learned a lot about how these conversations are developing in Brazil. And so that's really refreshing as a change to the kind of usual conversations you have with folks who talk about how things have developed over the course of many years in the US, the EU, etc. So it was great to talk to Professor Branco about the Brazilian experience.
Awesome. We hope you've enjoyed this conversation. Thanks for tuning in and listening. Bye bye.
We would love to hear your thoughts on the episode and your suggestions on what topics you would like us to cover. You can reach out to us through email or find us on our social media. We will link to details of these in the show notes. Lastly, we would like to thank National Law University Delhi and the Friedrich Naumann Foundation for Freedom for their support in creating the podcast. If you enjoyed the conversation, please like and subscribe wherever you're listening to the podcast. We look forward to bringing you more content. This podcast is created by Center for Communication Governance at National Law University Delhi. This episode was edited by Ananya and Gopika.